right, we are on the record in case number D336089. Appearances, please.
Good afternoon, Your Honor. Marshal Willick, 2515, former counsel for Yoli D'Acosta, on behalf of myself and my firm.
All right.
I don't think he's withdrawn yet, Your Honor.
What's that?
He hasn't withdrawn yet.
I thought we had.
No. Eva Garcia Mendoza on behalf of Yoli Acosta, only for the purpose of this motion.
Limited appearance. All right.
I'll double check that.
What did you say hasn't withdrawn?
She just said I haven't withdrawn. I thought we had. I got a notice from Ms. Mendoza on October 11th telling us to stop work.
Yeah.
And it was my understanding that we were out of the case.
Submit us something showing that you'd withdrawn? Well, let's see.
I'm not going to argue with her, but that was what I was told.
I've got a minute order, but excuse me, the minutes, but they're not the latest.
Find out just one second.
That's possible, my staff.
It does not look like there has been a notice of withdrawal.
Well, and possibly it's my staff's misunderstanding of the filings, because we've got filings from what looks like successor counsel, meaning Ms. Mendoza, and perhaps they just misinterpreted that as a replacement rather than. But I'll file a formal notice of withdrawal.
All right. Okay. All right, Mr. Wilk, this is your motion initially.
Very good, Your Honor. Just to make sure we're all on the same page, you should have a motion filed November 3rd and opposition filed by Ms. Mendoza on November 28th, and a reply filed December 11th with exhibits. I'm going to presume, unless you tell me otherwise, that the court has received and reviewed all the relevant documentation.
Okay, yeah, I've got all the documents. You've got the supplemental exhibit to defendant's opposition filed December 19th.
Not with me, but if you say it's on record.
It was electronically filed if you're in the system.
And I'm sure that we did receive it, in which case I simply don't have a copy of it. I don't.
No, it's mine.
That's what I mean.
Yeah.
In which case I just don't have a copy of it with me, whatever it is. Interesting.
It's a compilation of either a text message and an email between Ms. Fish and Ms. Acosta.
I think I did see that.
From December of 2016.
Okay. I think that largely replicates some of the materials that are in our exhibits to our reply. So it's probably pretty much the same stuff.
Right.
There's also an affidavit of Faith Fish describing her communication history with Ms. D'Acosta at the back of those exhibits. Because there seemed to be some confusion in the filings as to what happened in which order, we went ahead and did a graphical representation of the order of events just to make sure we're all on the same page, because it isn't. It's a demonstrative. I haven't admitted it, but it's simply a compilation of which documents, which documents actually hit the court file when. So
You haven't had a chance to see it before now, Ms. Fish?
No, Your Honor.
no, we just created this a bit ago, but there's only like 8 items on it, and I don't think any of these are debatable. I'll answer any questions the court has, but we see this as an extremely simple contract action. We signed an agreement after extended consultation with Yoli for what she wanted to do at her request back in August of 2015. We then did a bunch of work for a bunch of months. We finally got an order retitling Crestview in February of 2016. Title has been transferred. Yoli has put the house up for sale. And then 6 months later, we got a letter saying, we're not going to pay you. So we really think it's that simple. We want either the house to be appraised and we get 1/3 of that, which is what our contract calls for, or for the house to be immediately sold and we get 1/3 of that. Either way, okay, we want the benefit of our bargain, and we'll go. You have a timeline showing you each one of the major items. Yoli apparently, and apparently through her children, has decided that she's no longer going to chase Raphael. And that's great, but we still have 2 years of work we want to get paid for. And a house that we managed to get retitled as partial collection that our contingency agreement says we're entitled to a third of. If she doesn't want to go after all the rest of it, okay.
So Crestview, it's been a few years, Mr. Rowe. Crestview was initially ordered to Raphael.
Yes, Your Honor. Yeah, Crestview is the Mount Charleston home, and he claimed it as a homestead. And that was why in the 2015 proceedings, you denied our initial request to have that transferred to Yoli. You should have notes from the 2015 proceedings. They didn't, because it's something that didn't happen, there's no order from it. But you should have notes in your file from the 2015 proceedings. I'm trying to remember who my opponent was, Richard McKnight, I think, who said it's his homestead, you can't collect it, and you said, yep, you can't do anything with that. And so for 2015, we didn't get anywhere. But at the end of that, Raphael left the country, said he was never coming back. You eventually issued a bench warrant, and there's a bunch of, I'm not going to recount the whole procedure. You eventually made a bunch of other orders, and that left Crestview subject to relitigation. So we tried again in 2016, and we managed to get an order on January 7, 2016, retitling Crestview, which was the very first asset we were going to try to liquidate to finance all the overseas work we have to do. Because right now we've got an attorney in Peru who's geared up and ready to go for those 2 buildings that you already know about. But he wanted substantial amounts of money to do all that. Yoli didn't want to front it. We didn't want to front it. So we were going to use the Crestview money to finance it, our share of the Crestview money, and use that to try to get the, I think it was the Mambo Jumbo building.
That's the one that was 1/3, was supposed to be between the spouses.
Right. And so we managed to get in 2016, I think, we managed to get an order from you transferring that 1/3 interest over to Yoli. But there's a bunch of legal work that has to be done in Peru because they won't simply honor your order to turn that, well, I mean no disrespect, but they won't. We have to turn that order into an enforceable transfer down there, and it was going to cost many thousands of dollars. So we were going to use the Crestview money. As that's set up in the correspondence over and over again. So there was never any great secret as to what we were doing or when we were doing it. But since we've been dismissed, we're not going to be doing any of that. Sure. So we just want to get paid and go off.
I did read that you, I assume in one of the letters that you sent to Ms. Giacosta, the reference $1.6 million fund that you were able to accumulate?
Yes. At some point, she had an advisor at UBS, I think it was, and we had, there's no billing records for this because we were on contingency by this point, we didn't keep track of it, but we had extensive discussions with her UBS financial advisor. Yoli is a bit of a spendthrift, and we did a projection as to how long the money would last, and the answer was not long enough. You're going to outlive your money, which is never a good sign. So we told her how much we had to get for her and the budget she had to be on in order to not run out of money and simply go broke. And she didn't like that idea at all, refused to go into a spendthrift trust, refused to have a budget, refused to allow us to continue having discussions with her financial advisor and continue living off the principal. So how much money she's got now, I really don't know. She probably has enough to pay us the entirety of our interest in Crestview, and that's fine. So we'll either take 1/3 of the appraised value and we'll go away and she can sell it or keep it or do whatever she wants with it, or she can promptly sell it. It's still for sale according to MLS, and we'll take 1/3 of the actual proceeds so we can save the cost of an appraisal. We don't care how, but we would like to get it done.
So I guess I'll go right to this, and then I'll give you an opportunity if you wish. attached to your, as one of the exhibits in your exhibits to apply to opposition.
Yes.
A copy of the contingency fee agreement. I assume that's the same one as your signed.
I think there's a couple copies in here, but the signed one is in here somewhere. There's a couple of blank ones, but yes, the one. Let me pull up the right one.
Well, I would imagine that if there are any variations in the different copies, that they were
Yes.
relatively
It
insignificant.
is Exhibit 1 to.
Yeah, Exhibit 1 to your exhibits to apply.
Right.
What I was looking at, and page 4, internal 4 of the document itself. Right above the number 6, disclaimer guarantee, is a sentence that reads, if for any reason attorney will expend costs on client's behalf, there has not been paid by client prior to the conclusion of the case, and no recovery is obtained, the client must reimburse attorney for all such costs within 30 days of the unsuccessful conclusion of the case. Why does that not apply in this case?
Because there has not been an unsuccessful conclusion of the case. We succeeded in getting a valuable asset.
So you're saying it was the transfer of title that entitled you to...
The 1/3 contingency, yeah. That term is right. That's a secondary term just relating to costs. But one moment. The operative term here is at the top of page 2. We get 1/3 of amounts received. Amounts received means anything of value, including money or other property, whether tangible or intangible, real or personal, received from others, such as the adverse party, potentially adverse parties, or others paying on their behalf, by compromise, agreement, settlement, judgment, verdict, etc. And then it talks about structured settlements, which we don't have here. So, yeah, the operative term is at the top of page 2, but there has been no unsuccessful resolution at the end of the case because we got a house. If the court has any other questions, I'll answer them.
That was the main one. Counsel?
Well, Your Honor, do you mind
I have read everything.
do you mind if I sit?
Yeah, that's fine.
I wish it were as simple as Mr. Willick has put it, but I've got about, you've read our brief, and I've got about 20 pages of notes, but if you want me to sum it up, number one, we have questions of material fact. Mr. Willick starts out by saying that the contract was changed at Ms. DiAcosta's request. She denies that. There's an exhibit where Mr. Willick sends her a letter. I think it's the very first Exhibit A of their list of exhibits. It would be base stamp 1YD.
Right.
Where
3 options letter?
Yeah, the 3 options letter. And he speaks to her in a condescending manner. She's saying, it appears that we have to revisit this. This is going to be the last time that I'm going to go over this with you. And then Exhibit B, which is the base stamp 3YD, is a letter dated about a week later on August 7th, 2015, and says, you told me before court the other day that you still aren't entirely sure you understand how contingency fees work. Then we have the text or email messages between Mr. Willick's sister Faith and my client, where she is asking, now explain that to me again. And in spite of all of that, Mr. Willick doesn't send her to an impartial, another attorney. In fact, he should insist on it. Mr. Willick should have paid for it to make sure that she fully understood what she was signing. Any lawyer with 1 year experience would have known to exclude any property from Clark County in that contingency agreement, because that would be like shooting fish in a barrel. Property was there. All he had to do was submit the deed to you. He had begun filing motions. I mean, he stated that it didn't start until 2016. I submit to Your Honor, because we've taken a look at the minutes, that it actually started April 28, 2015, when he filed a motion for an order to show cause for failure to comply with the requirements to cooperate in the sale of Peruvian properties and for attorney fees, and that's where they start talking about the Mount Charleston property. That motion was canceled. Then on May 20th, 2015, there was a supplemental filing of that same order to show cause. Then on 7/5/15, the court issued an order, even though the minutes say that the result was matter continued. That's wrong, because I've attached a copy of the order in our list of documents. I'll find it for you. That would be Exhibit 11 is the order that resulted from that August 5th hearing. And then there's another hearing. Excuse me. There was an order from a July 8th, 15 hearing, which is Exhibit 11, and then there's an order, which is our Exhibit 12, from a hearing on August 5th, 2015. This new agreement doesn't get signed until August 25th, 2015. So Mr. Willick had already done everything that needed to be done to get that property to Yoli. Your Honor had already issued the order. All he had to do was submit the grant, bargain, and sale deed, and it was hers. And he held on to that until Ms. D'Acosta could sign that new agreement, which he pushed on her, not that she wanted. And now he says, aha, now instead of getting my hourly, which is only worth $7,000 and change, I want $200,000. And that's where it gets very sticky. And Your Honor, as we put in our papers, and if you, as you say, you've read everything, and I don't want to go through it, but then we've got the our supplemental exhibit, which I just talked about from Faith, which
December 2015.
yes, which starts out December 14th and December 15th, where my client again is saying, I don't understand. And if you take a look at these, the letters, the two letters from Mr. Willick that are very condescending and very insulting and very scary to her, an unsophisticated person who doesn't understand English very well, and you can tell that by the way she writes in these texts or email messages. And he is saying to her, we are your savior. If you don't go with us, you are going to lose everything. And in this letter, she's asking again, now what is it that I'm going to pay you? And even the letters from Mr. Willick, as well as this text message or email message from Faith, say, you don't pay attorney fees. You will not owe us. And there is nothing in this fee agreement, as you pointed out, that says what will happen when Mrs. D'Acosta fires them or terminates the agreement. What amount is owed? I mean, normal fee agreements will say you will owe us hourly rate and we have worked so many hours. That's normally the way we do our personal injury fee agreements. But that's not contained in here. Faith specifically says on December 14, 2016, our attorney fees are not charged to you. Now, they're charged to her one way or the other. They're either charged directly or they take it from her asset, but it's still charged to her because it's her asset. So how can they put that in writing and say, you're not paying us attorney fees? And then Mr. Willick admitted here today, and it's also set forth in Faith's text message or email message, that says, the money our firm gets from the sale of Crestview will be used to pay upfront costs for the fishing expedition in South America, as he calls it. Well, since that's over and he's not doing it, then he's not going to get the $200,000. All he should get is the hourly.
Well, quite frankly, if I can interrupt, Mr. Wood, I did have an issue with, at least from Faith's December 15 explanations. It almost appeared as though there was an understanding between you and Ms. DaCosta that wasn't included in the contingency fee agreement, that you were rolling these funds, your portion of the proceeds from each sale, you were going to roll that over as your own investment into the next recovery. And since that is now off the table, since she's terminated your services.
It's explained, if I can answer. In my letter, she doesn't want to be paying anything up front, so we agreed to front it for her for as long as she wanted to continue pursuing further assets. We would use our share, if she took the contingency option, to fund the next stage of attempting to get further assets. That's not a backtrack. That's an additional benefit to her. Normally, that would be her expense, but we agreed to front that because she didn't want to front any lawyer expenses anywhere. That was her single most important goal. Didn't want to spend any money up front. Only wanted to pay a piece of whatever we got. I don't know that I could have explained things any more clearly than I did in August. And the problem that I've got with counsel's recitation is that it's...
I'll give you a chance to tell me what your problem is.
Oh, I'm sorry.
No, it's just as an aside. Go ahead.
And so this email message from Faith on December 14th, she says, we need a decision by Friday. Friday was the very next day. So they're putting a lot of pressure on her when she's still having all kinds of reservations about what they're asking her to do. The other issue that we have with Mount Charleston, which we pointed out, because we obtained a preliminary title report. The preliminary title report indicates that the property is encumbered on the principal amount of $550,000. Once you add interest on it, it's going to be way above $600,000. So has he secured a value for her, as the contingency agreement says, that we're securing something of value? No. He secured a pig in a poke. This property's worthless to her. And then when I send Mr. Willick the letter to stop work and said, send me an itemized statement of your fees so we can get paid, he immediately writes back to me and he says, okay, I want my costs and I want $7,442.50 as my fees, which is our Exhibit 7. And then there's a footnote in there, which I didn't see until this morning preparing for it. And in his letter on page 2, he says, this is much less than the time actually spent working for you, a great deal of which has not even been tracked as we were working under the contingency agreement. So even then, he rebukes and refutes the contingency agreement and agrees to go on an hourly for this. So we offer him $3,500.
Where is that at?
The footnote, Your Honor, that's Exhibit 7 of my exhibits.
Could you identify the date of the letter, please?
October 13th, on page 2. Your Honor, may I approach?
Yeah, you may, because I'm looking at a document. Exhibit 1 and 2. It doesn't have 3 through 11.
You don't have our exhibits?
Is that appendix?
Yeah, we noticed that the
The
exhibits...
exhibits are listed, but the only 2 that are attached are exhibits 1 and 2.
Well, Your Honor, we'll have to supplement the record then. If necessary, we'll ask for a continuance of this hearing because
That's
we were never advised.
I can help, I think. We noticed that when the filing came in, which is one reason the exhibits to the reply contain those documents. It's Exhibit F to the reply and it is the letter of October 13th to Ms. Mendoza, which attaches to it the letter that we had already written to Ms. D'Acosta, which we then redirected to Ms. Mendoza because she contacted us on the 10th and said that we should talk to her instead. So we simply redirected the letter, but it's on page 2. It's Bait Stamp 21YD.
And are you just representing that exhibits, the remaining of the exhibits that Ms. Garcia Mendoza says are attached are included in your reply?
It's been a couple months, so from memory, I can't say that every single one of them is, but this one is. The one she just referenced?
Yeah.
Certainly is. But I'm sorry, I'd have to look at the list side by side.
I also understand it's a Friday afternoon. So her Exhibit 3 is a statement of account for services rendered through October 16th. And at least from your title, it doesn't appear that that's included in your Exhibits B through I. Letters, plus it was attached to a letter. We'll revisit this issue in a few minutes. Why don't you proceed?
Your Honor, and then we have another text or email message from my client to Faith, and then you're telling me you don't have, which is our Exhibit 4, and then I think you need to
Right.
have also. But she's telling Faith again, this exhibit actually postdates, in our brief we say that this exhibit is in January, whereas the supplemental one was in December. And so my client is still going on saying, please stop, there's no way you're ever going to get Raphael because he's too rich and too smart and he's out of the country and I'm tired. I've been fighting this case, Raphael, for 6 years and I'm done. I don't want to keep it. I want some stability in my life. So, as I say, Mr. Willick says in that letter, we had the contingency agreement, but I just want my fees of $7,000 and change. $7,440.50. And then, after our offer of $3,500, he comes back, changes his mind, and says, "Oh, forget it. I want $600,000." Mr. Willick and I had a long conversation. I tried to bargain with him, and he was adamant. I'm sorry, $200,000. The property value is $600,000, and we were unable to come to a resolution, and so I think within days he filed the motion for fees. So, Your Honors, we've said, first of all, if we're going to look at considering this motion for fees, other than the initial fee agreement that was signed, which was the hourly, I submit that Mr. Willick must file a new complaint and let us do the discovery and let a judge decide what, if anything, he's entitled to. We've also argued that the contingency agreement violates Rule of Professional Conduct 1.5. We cite the Marquis and Arbach case. We also say that it violates same Rule 1.5 because it is not reasonable and didn't advise her in writing of her other options prior to signing, nor did it advise, nor was there anything.
So let me interrupt you. So, okay, so the allegation that the contingency fee agreement was not reasonable. I mean, how do we define what's reasonable?
Well, if he's going to shoot fish in a barrel and he knows that all he's got to do is submit that deed to you and he's got $200,000, is that reasonable, Your Honor? Because he's already done all the work going back to 2014 as I just went through this.
Prior to
Seeking that property. He's charged her for it. She's paid him for it. And he's just holding back, waiting to see if she's gullible enough to say, I'm going to get her and I'm going to make a bunch of money on this one just by doing very little work. And he showed how little work he does because he was honest enough to send me his hourly billing. And so how can you say that $7,000 versus $200,000 is reasonable? I mean, it just, there's no sense in it. And to hear him say just now that, well, we weren't going to pay the cost, she was going to have to pay them, that's not in the contingency agreement. Once again, I practice a lot of personal injury law, and there it says that we will advance all the costs. Here, he's unwilling to do that, so he wants a contingency, but he wants a hybrid contingency where he wants her to pay the costs, and he just wants to sit back and get the glory.
Where was his request that she pay the costs on the trustee property? Is that in the...
It's on the contingency fee agreement that she pays his out-of-pocket costs. But didn't you just read it, Your Honor?
Yeah, I read it, but I didn't pay attention to that part of it. Under costs and expenses, initial costs must agree to be prepaid beforehand. All initial expenses shall be reimbursed with funds collected.
The definition of costs is on page 1 at footnote 1 under legal fees.
Yeah, no, I mean, I'm not disputing that you're entitled to get the costs. But my reading of the agreement, and I thought you were saying otherwise, was that the costs would be paid up front on you and deducted from whatever was collected before the net amount from what was collected was distributed 1/3, 2/3.
We may be talking about two different things.
Sorry?
We may be talking about two different things. This last sentence, any attorney, whether domestic or foreign, hired by us to accomplish a collection will be paid from our share of the money collected. Those are the kind of costs that we're talking about. Is money we have to pay to third parties to do stuff because we had planned a great deal of international work. And she didn't want to be out of pocket for any attorneys anywhere. So we made a point of defining those attorney's fee costs as our expenses, and if you look at my two very lengthy, very detailed, very clear letters, it explains the methodology and exactly how much money would end up in anybody's pocket at the end of the day from a hypothetical collection that we would do.
I may have misunderstood what you just said. Had you said that she was expected to pay the costs up front?
That's what he said.
See, I'm not seeing that in the agreement.
No, it's not in the agreement.
I'm seeing,
Right, correct.
it's not in the agreement.
Correct. It says it's at footnote 1. But yet in Faith's email and in Mr. Willick's 2 letters, and as he represented here at the onset of his argument, is he planned to use the money that he collected from this to fund his collection work in South America.
Right.
That's an additional benefit to the client.
Well, it's not important to the client where you get the money. I mean, attorneys can have a line of credit at a bank that will fund their litigation until they
But normally,
settles.
in most contingency agreements, call for the client to pay all of those hard costs. We agreed to pay them. We gave her an additional benefit over and above.
The agreement provided for the costs to be fronted by you, but being reimbursed once the settlement was made.
No, we would pay ourselves for those costs out of what we collected, if anything. If we never collected anything, we ate the costs. That's in my letter of.
I understand that.
Yeah.
That's what the judge is saying.
Oh, I'm sorry. Then we said the same thing.
Costs and expenses, initial costs, unless you agree otherwise, the costs for the collection action shall be reimbursed with the funds collected on behalf, reimbursed to you with the funds that are collected on distribution. I understood, Ms. Garcia Mendoza, what you just said was that she was expected to pay the costs up front. You didn't say that? I misunderstood.
No, that's what he said. He said in her letter, in his letter,
On his letter?
yeah, in his letter says, you know, if you don't want to take this option, then you've got to pay us all this stuff. Otherwise, and we're not going to give you, I don't know what kind of agreement he had for how long she could take to pay him, but she is represented under this opposition, verified opposition, that she's paid him over $1 million. So she doesn't owe him a lot of money.
For the actions prior to the collection.
Right.
The 6 years of litigation, yeah.
But, you know, we submit that this is not a collection action. This is still part of the divorce case.
I understand that issue.
Thank you, Ron. So, Your Honor, that's our position.
Mr. Look, on the reasonableness issue, can you explain that to me?
Sure.
$200,000 for, was it $1,700 costs?
Well, hard costs, all we were doing is rehabbing a house. This was stage one of years of anticipated work. We literally, and these names will sound familiar to you, well, you don't see all that work. That's what that footnote was for. We weren't even tracking our time. We were simply doing things. We've been in regular communication with Herman the German, who is now...
Got hold of Herman the German?
We did. He's in Panama, and we managed to track him down through the Peruvian attorney. But you won't see any of the costs or time that we spent dealing with the Peruvian attorneys, dealing with the Nicaraguan attorneys, dealing with the Panamanian attorneys, dealing with the various witnesses, researching construction companies, getting our evidence together, because we weren't keeping track of the time. The letter that she's referring to was sent in error. My staff just screwed up, put it in front of me, and I signed it. And that's probably a mistake. I got to be better than that.
Which letter is that?
The letter that said that we'll settle for our time involved, because they got the year wrong. They misunderstood what we did and when we did it. And after that letter went out, I went back down the hallway, and I said, wait a minute, we got this house under a contingency agreement. And I was told, no, this was back during the other litigation before that. I said, I don't think so. Go back and check the dates. They went ahead and checked the dates, and no. You had already denied us the Crestview house. So this wasn't a fish in a barrel situation. This was going in front of a judge on an already denied motion. The request had been denied. It should be sitting in your notes from the 2014 and 2015 proceedings, because it was homesteaded. It wasn't until later, when Raphael skipped the country and we got an arrest warrant and refiled a new motion in January of 2016, that you went ahead and allowed us to get the Crestview house. Counsel, as far as I can tell, is simply making up anything in the county is exempt. I don't know where the heck she gets that. I've never had such a rule. I've taken contingency cases for things that I've only done in this city, because this is where I work. There's no such thing about exempting property that's within the county. That's just silly. In terms of, read the motion of January 7th. It sets out the procedural history. This is not a hybrid request. It's a straight contingency. We explain it in gory detail over and over and over again. If counsel wants to characterize it as condescending, she can, but I've worked for this woman for 6 years. I communicate with her in words that she understands, and she does understand. If we succeed in ultimately getting and liquidating the condo, you will have spent nothing out of pocket during the process, whether by negotiation or by litigation, but you would get 2/3 of the eventual recovery, and we would receive 1/3. So you would spend nothing but receive about $335,000. In this scenario, the cost of any Mexican or other attorneys would be borne by us. Whether we make some deal to pay them out of what we get if we're successful, or we pay them hourly out of our own funds, or however else we get the attorneys, experts, appraisers, etc. to do the work required in the other location. Your recovery would be the same, and ours would be lowered by whatever it cost us to get the result. The choice that she had in July was not between contingency and hourly. She told us she wasn't going to pay another attorney's fee bill. I said, great, then we're not going to do any more work. In which case, goodbye and have a nice life. If you want us to do more work, you either have to say that you want to pay us hourly, or you've got to hire us on a contingency basis. And she insisted on a contingency basis. We had a 2-hour meeting where I graphed it all on the chalkboard and went over all of these numbers.
Your Honor, we have an unverified motion, and everything that he's arguing now is not before the court.
Of course it's before the
court. Before the court.
Of course it is. You've got an affidavit, a declaration of Faith Fish.
Faith. Faith, is she practicing law now?
She's the firm
Without a
administrator.
license?
She's the firm administrator who was the translator in all of these conversations because Yoli wanted to have everything read to her. So the declaration says, I read all this stuff to her, made sure she understood everything, and she did. She was present taking notes during the meeting that I was just telling you about. The hour-and-a-half meeting where I graphed it all on the chalkboard showed her exactly how many dollars would come out in which scenario. And that was in the summertime. And in terms of Ms. Mendoza's statement about I had to send her to a third-party advisor, she told me she had a third-party advisor. And that third-party advisor is recited on paragraphs 9 and 10 of Faith's declaration. Soon after, Yoli indicated she wanted additional information about contingency agreements to have a document that she could discuss with her advisor. In response, we sent her another letter on August 7th. And then she says, although I have no independent memory of it, I'm certain I discussed the letter with her over the phone as well. Additionally, prior to executing the new agreement, I had the opportunity to read the agreement to her in person. Every term was explained. Every question was answered at that time. So she got multiple written explanations, all of which we've complied with. She got multiple oral conversations. She had a third-party advisor. She took a month and a half to think about it, and she decided she wanted a contingency agreement. I defy anyone to go to greater lengths to make sure that the client is adequately informed.
Well, then let's do discovery on this to find out.
There's no discovery to do. After Landreth, letting a judge decide, we have a judge. And you've been specifically empowered to decide. In terms of this lien proceeding, well, it's not a lien proceeding, but take a look at the last lien case. We know from the last lien case that under 18010, as it's been reconstituted, you have full authority. We know under Landreth that you have the same powers as any other judge. I mean, Ms. Mendoza's statement that we didn't advise her in writing of her option, yet nobody with a straight face can read these 3 letters and say that. It's impossible to be more clear. It's physically impossible.
Where is a separate consideration for changing the fee agreement?
She demanded it, as we confirmed in writing multiple times.
And she denied
Now,
it.
this decision, hang on, I don't want to end up in a side argument. Her position that there was some decision to be made in December 14th, that wasn't whether or not to be on contingency. That agreement had been made back in July of 2015. December of 2016, what she was talking about was whether she wanted to go forward or stop. We'd already got the Crestview house 8 months earlier. So this December decision that she had to make was, you want us to go and do more or not go and do more? May decide either way, but it has nothing to do with Crestview. Crestview was completed as of February 2016, and it was initiated in January of 2016.
Okay, let me ask you, and I think you will need to supplement the record with missing exhibits, because one of your missing exhibits is the title. The public title report. Mr. Willick, you say there are no liens, it's free and clear?
Well, I can't represent that. We did a title search, and no significant encumbrances show up. We saw the reference from Ms. Mendoza. We don't know what it is. It may be my lien that I filed. Well, you remember, if you roll back to 2014, you may recall that Raphael was attempting to liquidate the house. We were concerned if he liquidated it, the homestead exemption would have been lost. It would no longer be protected property, it would be money. So what we did in 2014 is we filed a lien on behalf of Yoli to secure the back alimony and the some piece of the property judgment that was owed. And I filed that, I can't tell you exactly when, but way back. When Raphael found out that we had perfected a lien, he abandoned his attempts to sell the house. It was after that, while he still had his homestead exemption, that you denied us our collection against the house. And it was after that, when he fled the country, that he lost the homestead protection because he had declared through Mr. McKnight that he was never going to return to the United States, was not ever going to live in this house. And so it was in 2016 that you told us, well, homestead protections are gone because of stuff that frankly hadn't happened until after we were on contingency. So we were then able to start collection. So there was no plot, there was no plan, there was no I can take advantage of her. All this stuff happened in the order that your notes should show. I mean, you were there.
I guess one other question, and I'll wait for the supplemental filing and then review everything and make a minute order decision. The question is this, you just recounted a few minutes ago extensive costs that were incurred vis-a-vis Panama, Irma the German.
Well, they weren't costs, they were time. I'm not going to allege any significant, I mean, long distance.
Right, so other than this particular action, you have no other incurred costs?
No, I'm not willing to say that. The only time that we tracked is the time that I reported to Ms. Mendoza. I'm reporting to the court, as a matter of candor to the court, that we were already in preparation for all of these other things. We've had attorneys in multiple countries. We've done investigation in multiple countries. But the actual hard costs of getting your order turned into an enforceable judgment was beyond the scope of what we could front with the sums that we were willing to risk. So we put that off until after this sale went through and we got our share of this contingency. We were then going to spend the estimated thousands or tens of thousands, I don't recall exactly, that's necessary to fund the legal action in Peru to retitle the Mambo Jumbo building in order to allow for the forced liquidation of the secondary real estate there, because we knew that would cost us a bunch of money that we just didn't have on hand. So we explained in writing multiple times that we weren't going to start doing that until we cleared the money from Crestview, because we were going to use that money at our expense to pay those other lawyers to do the prep work to try to secure additional assets.
All right, when
It'll be done early next week, Your Honor.
right, next week? Okay. All right, I'm going to just put a date out 1 month. Hopefully I'll be able to vacate it in a minute or
Okay.
it's more of a holding note so I don't lose the case. Just a status check date.
We're adjourned for the last 2 weeks of next month, so can we go March 6th?
Yeah, the first date I'm back.
March 6th at 11 a.m.
I'm in an all-day evidentiary on the other side of town.
Okay, so you don't need to, neither one of you need to be here on March 6th. This is kind of a reminder to me. And if I don't have it done by March 6th, I'll do another date 2 weeks after that. So
Thank you for that
so
courtesy.
I don't lose the case. I don't take it off calendar for the decision.
Sure. So we can consider this a Chambers calendar setting?
Yeah. Except I don't know what the hell a Chambers calendar is, so.
Well, you managed to get out of that lie.
lie.
Yeah. We now have those. It was the last rule rewrite.
Yeah, I know, I heard other judges talking about
A little tiny baby step toward the Reno model.
All right, thank you, Ron.
All right, thank you.
Yeah, and of course, if when you review whatever is
If
about
I
to
have
come in,
additional questions, then I'll notify. You're going to be in Maui for 2 weeks?
Yeah,
When?
the 7th through the 17th.
7th to the 17th. I won't call during that time, but
very good, Ron. Thank you for the time.